Morris Williamson.
Mr Speaker, I move that the Crown Pastoral Land Rent for Pastoral Leases Amendment Bill 2010 be now read a first time. At the appropriate time, I intend to move that the bill be considered by the Primary Production Committee, that the committee present its final report on or before the 5th of July 2011, and that the committee have authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day in which there has been a sitting of the House, and on a Friday in a week where there has been a sitting of the House, and outside the Wellington area despite Standing Orders 187, 189A and 191B and C. Mr Speaker, I'm really pleased to be introducing this bill tonight, which amends the Crown Pastoral Land Act 1998 to set in place what I think is now a robust and a fair new system for charging rent for South Island High Country pastoral leases. In July 2009, sir, the government agreed lessees will be charged rent on the basis of the earnings capacity of the property. We've done this because the present rent system, which is based on the land value, is both unworkable and the source of dispute between the Crown and lessees. Mr Speaker, it is quite clear that these properties don't earn a lot of money just because the sheep can get a lovely view of a lake or a mountain, and therefore it is wrong to just charge based on the view. Well, actually, Mr Cosgrove might have a different view of sheep than that, but all I can tell you is that that's not our view. Sir, I'm happy to report a high degree of support from the high country farmers for the approach that we have adopted in this scheme. Notably, environmental groups who have views on pastoral lease management have not raised any concerns about what we are proposing in this legislation. Mr Speaker, it's been a lot of work. We went right back to the drawing board to achieve our goal of implementing earning capacity rents for Crown pastoral leases. This bill proposes replacing what I think is an unworkable land value system with a system based on the productive capacity of the land. Rents will be set by capturing the carrying capacity of a lease in standard stock units and applying a dollar value to those stock units using objective information about the current economics of high country farming. Mr Speaker, under this bill, scientific information about the characteristics of the land in a lease, such as aspect and temperature, along with a detailed assessment of the land itself, will be used as an easily calculated proxy to determine the carrying capacity of the land in its original state. And that's a very important element, in its original state, because we do not want to penalise those people who actively work to increase that capacity. This base carrying capacity will be set once for each lease and will not change. This alone will remove a major source of contention between the Crown and lessees when setting rents. The process, sir, will then assess how much stock the land can plausibly carry at the time a rent is reviewed, so it can be measured how far production has increased. The Crown will collect rent on the base production plus 15% of the increase. In other words, somebody who's really farming it well and gets a substantially increased across the base carrying capacity can extract 85% of that gain for themselves, the Crown taking a 15% of it. Ministers gave careful thought to the setting of this percentage. We agreed that rent must be paid on the base production and 15% of the increased production. That's what was finally determined. We felt this fairly represents the land and the development opportunity the Crown has provided to the lessees. Implicitly then, as I said, the other 85% of the increase is attributed to the work lessees have done on the land and paid for over the years. Their own work and investment will not increase the rent that they pay. Crucially, this 15% conforms with the property rights that are inherent in a pastoral lease. We sought assurances on these property rights issues and other elements of the proposed system from an independent peer review panel comprising an ex-senior civil servant, a retired Supreme Court judge and a highly experienced valuer. The peer review panel endorsed the overall package of recommendations as a significant improvement over the current system. And finally, sir, the system takes the productive capacity of the lease, that is the base plus the 15%, and calculates any rents that are up for review by using an up-to-date rate calculated each year. This rate captures the current value of the production already assessed. Sir, I want to mention two further features of the new system. First, the bill sets out a cooperative approach to assessing the productive capacity of a pastoral lease, including a modern disputes resolution process for those cases where the Crown and the lessee can't agree. Mr. Speaker, there is one final part of the new system that I think needs mention. The bill contains an opt-in provision to allow lessees currently disputing rental valuations to have their rent set by the new system. As I mentioned before, sir, the existing system encourages disputes, and as I speak, 113 leases are currently before the Land Valuation Tribunal. At this rate, over half of all pastoral leases will be in dispute by the time this bill comes into force. This opt-in provision is a vital part of this bill. It allows for the equitable resolution of these disputes and a return to normality for the affected lessees. These lessees and other lessees in the future will be able to get back to the business that they know best, productive pastoral farming that contributes to the New Zealand economy. Finally, Mr. Speaker, I, along with my colleagues, the Minister for Agriculture and the Minister for Conservation, would very much like to extend the government's gratitude and thanks to all those who have been instrumental in developing this bill, because a lot of work and consultation was required to get there, sir. I want to particularly mention the peer review panel, as I did before, who did, I think, a sterling job. Jonathan Wallace and his colleagues from the High Country Accord, who obviously had an interest that they wanted to pursue, but, well, I don't know, no, David Parker says they won. I don't believe that. I actually believe this balance gets, well, it will be, and I will be very pleased to tell the South Island farmers that they think they rolled us, because I don't think that's how they see it. Sir, the High Country Accord, as I said, I wish to thank them. And, sir, can I just pay a real tribute to the officials from Land Information New Zealand, the Department of Conservation, the Ministry of Ag and Forestry and the Ministry of Justice. I think this is a particular example of legislation done in consultation with the interested parties in what I think was a fairly iterative process of getting to a place and a space where we all felt there was balance. And Crown law. How could I have not mentioned Crown law, Sir Geoffrey? I mean, how could I have... Mr Finlayson, how could I have not mentioned Crown law? Sir, I commend this bill to the House.
The question is that the